Hey everyone, this is Justin Gonzalez. I'm the marketing director here at Fishery David. I'm joined once again with Terry Roberts, our director of appellate practice. Terry, we had a third DCA render an opinion. What can you talk about this opinion?
Sure, this opinion is called Costco Wholesale Corporation versus Vargas. It was about a slip and fall at Costco, and it's really about discovery sanctions. There were two separate discovery sanctions that Costco appealed. They weren't happy about the sanctions, and they brought it up on appeal. The first related to interrogatories. So we put out some interrogatories. They objected to the interrogatories, which is fine. We filed a motion to compel responses to the interrogatories, and the court ruled that they had to answer. When they answered, they put out a second response to interrogatories that just said, basically, same objection as before, which is a big no-no once you've been ordered to respond. So we filed the first motion for sanctions. And before that came to hearing, they said, oh, wait, and they sent a different interrogatory response. And they also sent an affidavit of a paralegal saying I screwed up, it was my fault, even though the attorney had signed the discovery and is responsible for it. The important thing to remember about that is that the DCA through Chief Judge Logue says, look, you don't have to have bad faith or terrible intent or anything like that to be sanctioned. You basically have to be ordered to provide discovery and fail to do it. And then when the other party has to do a second round to get you to comply, they can get the costs of that. And the costs can include attorney's fees. And we got a small attorney fee award and some costs for that first sanction. The meat of the case really deals with the second discovery violation. And that was a little more juicy. It basically comes down to witness coaching or using a cheat sheet or a script at a deposition. We had taken the corporate representative deposition for Costco's corporate rep. And at the outset, John Fisher, one of our name partners, asked, do you have any documents you're relying on today? And the witness said no. And then Mr. Fisher got into questions about the factual basis for various affirmative defenses that they had raised. And that's fine. You can't ask about discussions with an attorney. You can't ask about legal conclusions. Does comparative fault apply in this case or anything? But you can ask about the factual basis. For instance, in a slip and fall, if they are going to argue that your client was running when they slipped and fell, the corporate rep should know about that. If there's a report from an employee, they have to talk about that. So when Mr. Fisher asked, what's your factual basis for this affirmative defense, it became obvious. This was a Zoom, a deposition done by remote, by Zoom. So he wasn't in the room and couldn't really see below the camera, but it became obvious from the guy's tone and where his eyes were. Mr. Fisher said, are you reading from something? And the witness, and I'm paraphrasing, and the witness said, yes, I'm reading from something. He said, well, what are you reading from? Well, my lawyer sent over this document. When I'm asked about this stuff, I can read this. And Mr. Fisher said, well, so you're just going to read the response that the attorney wrote for you. Are you prepared to talk further if I ask you more questions, to talk more about these issues, or are you just going to read what was provided? And the witness was pretty clear. I'm going to read what's here. I'm not going to say anything else. That's the end of it. So Mr. Fisher suspended the deposition and filed a second motion for sanctions. And the trial judge basically agreed with us that the cheat sheet or a script or anything like that is a form of witness coaching. The lawyer can't do that. The witness has to answer as a witness. And during the deposition, the most extreme thing happened, and the thing that kind of outraged the trial judge the most, even though it's not directly mentioned in the appellate opinion, is that when the corporate representative is asked about one of these affirmative defenses, he starts reading something. And the lawyer says, hold on, you're reading from the wrong part, and directed him to read from a different part in forming his response. So this was a clear case of what the DCA used the word coaching witness. And in regard to the defense that, well, hey, I'm just trying to make sure that a corporate representative is answering consistently with the interrogatories that we've put out. The DCA said these problems are in no way justified by Costco's desire to ensure its representatives' answers stayed consistent with Costco's answers to interrogatories. To the contrary, exploring such inconsistencies is one function of a deposition. So it's fine, even with a corporate representative who is a bit of a mix of a real person and not a real person. It's fine for lawyers to try and find some inconsistencies with the corporate documents that have been put out and what the witness has to say on behalf of the corporation. And you can't have some sort of puppet master or coaching or script or something written by the lawyer. So they affirmed the sanctions, both forms of sanctions. There's going to be small, attorney's fees and costs awarded, and we've got this written opinion that has already gotten some comments from the legal community of support. We've heard wonderful things from lawyers from other firms saying good job, and frankly, we've already in our practice come across a similar situation where we've been told flatly by a defense attorney, well, we always write the interrogatory responses for the client, which are supposed to come from the client. And in this case, it was an expert, not a corporate representative, but an expert, who then at the deposition said, I didn't ever see these interrogatory responses. I don't agree with what's written in them. And so we're probably going to be citing this opinion already. And I think that we're going to find that the practice of, especially defense attorneys when they're representing corporations as opposed to an individual, are inserting themselves as the witness more than we might think. And I think this opinion I could be proven wrong, but I think this opinion is going to be something that gets cited again and again in Florida courts, saying witnesses are witnesses, lawyers are lawyers, and the lawyer cannot testify for the client. And it could be, one of the important cases in Florida that say that.
Well, hopefully this opinion will be cited for many years to come. For all our viewers and listeners, you can find a link to the full opinion on our LinkedIn page or in the description. Terry, thank you again for joining me today. Keep up the great work as always, and thank you to everyone for joining us and listening in today.